Swayam Prabha. Digital India. Educated India.
Dear students, and today we are going to discuss abuse of dominance and combinations as a part of our competition law class. And we last class we already discussed about the anti-competitive agreements, and today we will discuss in detail what is abuse of dominance and also the other areas of the competition law. And you may be heard about the abuse of dominance, but what is this abuse of dominance actually is? And abuse of dominant position is basically the strength enjoyed by any enterprise, any corporate enterprise which enabled them to act independently in the market and also to influence the market. And this enterprise position and is which is disregard of other market forces, and in order to eliminate all kind of competitions. So, these business enterprises uses its market power to eliminate the competition from the market, then they will be abusing the dominance in market, abuse of dominance in the market. And we can see that this abuse of dominance there are various forms, which is the price fixing. It is in the form of price fixing, it is non-discriminatory pricing practices, predatory pricing, and limiting supply of goods and services in the market that make a scarcity in the market, then denial of market access like refusal to deal. And again we can see these there are components, what you mean by the elements that constitute the dominant position. And when an enterprise, business enterprises is going to be in a dominant position in the market, and always the position, it is a position of strength accumulated in a period of time due to the technology, due to market conditions, and due to certain homogenical conditions which is available in the market. And such position is enjoyed by the enterprise in the Indian market, and also with the product market and geographical market, and both the markets which we will see later on what is this geographical market and also the product market later on. And it means that these enterprises, these companies can act in the market irrespective of the competitive process in the market, and these companies and enterprises are a force in the market which uses its dominant position irrespective of the competition process in the market. And also they can impose other trading conditions, and the trading conditions which are not acceptable to others, but there is no other choice for them to avail these services or the goods. And actually the abuse of dominant position in the market is considered to be a threat, a strong threat to the free market. And basically these are the firm's ability to raise the prices to unreasonable extent, and which the customers can charge, and also they can go for the alternative source of supplies. Then again which you can see that the firms uses its dominant position which will affect the market forces, and ultimately eliminates the competitors from the market. And again the monopolization or the dominant position in the market per se is not illegal under the Competition Act, but the abuse of such position, only the such abuse of such positions are illegal under the Competition Act. And especially these power of strong power of the big industrial houses or enterprise which use their market power to eliminate others from the market or eliminate competition from the market or eliminate the rivals from the market, then only it will be considered as a violation of competition law. And such behavior, when such behavior become, or what are such behaviors which become abuse of dominance, we have to see in detail. So, the Competition Act of India under section 4(2), which prevents certain activities which resulting in the abuse of dominant position. They are imposing unfair and discriminatory conditions or prices in sale and purchase of goods and services will be considered as abuse of dominant position, and other characters such as limiting or restricting production of goods and services also will be considered as abuse of dominant position. Then technical or scientific development relating to goods or services to the prejudice of consumers also will be considered as the abuse of dominant position. Then most importantly, denial of market access, that is refusal to deal, tying agreements, refusal to deal and tying agreements, which we discussed in the last class as well. Then again using the dominant position of an enterprise to enter into another market, using that particular power to enter into another market also will be considered as abuse of dominant position. And if you look into some of the examples of dominant position is predatory pricing, granting loyalty rebates or allowing royalty rebates, then tying and bundling, refusal to deal, margin schemes and exclusive agreements. All these are considered as abuse of dominant position, and we will see elaborately one by one. And predatory pricing is one of the prominent form of abuse of dominant position. This is nothing but you reduce the prices below the cost of production in order to eliminate, in order to send out the competitor from the market. So, here you can see that it is very clearly says the objective or the intention of the prominent player in the market is with predatory intent, and predation is something which want to eliminate the competitors from the market, so that later on they can capture the market and they have become more and more stronger in the market. So, in this particular case, Neeraj Malhotra Advocates versus North Delhi Power Limited, the Competition Commission of India very clearly said that section 4 of the Competition Act does not prohibit any enterprises from holding dominant position in the market. So, it means that dominant position in the market per se is not violative of any competition law. So, but in order to achieve the dominant position, if they abuse their dominant position in the market, then only it is actionable under the competition law of India. And predatory pricing always, as I told you, forcing somebody out of the market because of the market conditions, because of the lower price imposed by the market major or who plays a dominant position in the market. So, here also you can see that the dominant, once the dominant company has successfully excluded all competitors from the market, then they can capture the entire market. So, there is a free ride in the market. So, it means that even in the initial times, if the company goes running on is not making profits, later on once you send out all the competitors from the market, they can impose higher prices and make profits out of the market. And then again loyalty rebates. Loyalty rebates are considered to be another form of the use of or abuse of market position or abuse of dominant position. This is nothing but the loyalty rebates, which is a refund. A refund is given to the customers when they is past certain threshold limit of quantity or threshold limit of the total purchase amount. So, that these customers will be always compelled to go to these particular suppliers. So, these loyalty rebates which preventing other companies from entering into the market or preventing the customers from going to them. So, it means that this is a kind of incentive given to the customers to go to a particular supplier who may be a major or a prominent player in the market. Such arrangements are basically, you can see that very much prevalent in the e-commerce market. Cashback. So, cashback policies are nothing but loyalty rebates. So, once you are availing services or purchasing goods. Then tying and bundling which we discussed in the last class as well, and tying is nothing but tying tying of two products, that is the one is you require and another one you do not require. So, tied the goods and services with each other will be also considered as abuse of the dominant position. So, here you can see that you sell some of the product as a package which you may require or you may not require. So, you tie a wanted product with an unwanted product, and that is the tying and bundling, which will be considered as abuse of dominant position. Then again refusal to deal, unreasonable conditions. So, always the dominant firm have the freedom to choose or conducts the business according to their choice. The last class which we talked about the horizontal and vertical agreements, what are the type of agreements, and these vertical and horizontal agreements which ultimately eliminate the competitors from the market. So, that the dominant firm can charge whatever they want to charge on the or exploit the market to beyond the competition process in the market. So, actually if you refuse to deal in the western countries, the concept of essential facilities doctrine has been evolved in a period of time, where you are forced to license that your technologies to a person for a limited for a royalty which is determined them, which must be very reasonable royalty. So, you cannot say, you cannot simply refuse to deal in if you apply the essential facilities doctrine. And this essential facilities doctrine jurisprudence is evolving not only in the developed countries, but also it is coming to the developing countries like in India, which was applied in the Micromax versus Ericsson case. So, you can see that these concepts which again facilitates the market conditions, dominant positions. And another is margin skews, and here also is in vertically integrated undertakings, that is an upstream market and also the downstream markets. So, the distributors and retailers, the market. So, the dominant firm try to control this, and again the dominant undertaking skews the downstream competitive margins. That means, the gap between the cost it is required inputs and the price it can achieve on the downstream market is very less. So, it means that by charging a high wholesale price and a low retail price or a combination of both, this will be considered as the margin squeeze. So, the competitors, there is no question of competition, because you are forced to purchase this even though there is a very limited margin in the particular products. Then exclusive agreements. So, the last class also which we talked about these exclusive agreements. So, here the prohibiting one party to enter into a similar contracts with other competitors, and third party to allow a dominant company to foreclose competition in the upstream and downstream markets. So, it prevents others from entering into any kind of contract with the competitors, also will be considered as the abuse of dominant position in the market. So, monopolization can happen in many ways. So, the elements of monopolization in the market which we can look into is the monopoly power itself. This power is acquired for a period of time due to different conditions, and one important condition is the allocation of resources. The huge firms spend lot of money for acquiring markets, then willful acquisition or maintenance of that particular power by superior product. It can be due to business acumen, or maybe it is just an accident in the market. So, the attempted monopolization, which you can always see the anti-competitive conduct of these bigger firms, and then and also the elements of conspiracy to monopolize, like cartelization, which we discussed in the last class. So, there will be a combination of conspiracy, conspiracy, or there is a agreements between different parties. All these are the symptoms of monopolization in the market, and the abuse of dominant position clearly in the section 4 there is a connectivity between section 19(4), which what are the factors to be taken into consideration for considering abuse of dominant position or abuse of if an enterprise or a group of people. So, it directly imposes unfair or discriminatory conditions always on the purchase of goods or services. Then secondly, the price or purchase of sale, that means the price may be a predatory price, that may be much lower than the cost of production in order to acquire a new market or to eliminate a competitor from the market. Then it is very clear that, so a dominant player in the market is not distorting any market. So, acquisition of dominant position is absolutely legal under the competition law, but its abuse is actually prohibited. So, the abuse of this dominant position may be exclusionary or exploitative in nature. So, exploitative abuses are, you can see that exploitation is basically on the consumer, exploitation of the market as such, and the exploitation, the monopoly power gradually leads to the monopoly profits, exorbitant profits, and which is directly affecting the consumer welfare. So, absolutely these are prohibited under the competition law, and excessive pricing may be one of the main reason of the abuse of or one of the considered as one of the main category of abuse of dominant position. And also you can say that it have an effect on the interstate trade as well. So, there must be effect on trade between members, implies that again there will be cross border economies, and now in a globalized world it is not only it can happen within a single economy or a single market, single geographical market. It can happen many geographical markets, many parts of the world, because it is integrated. Now, the world is integrated with international trade. So, this relevant geographical market definition is very relevant for considering the dominant position. So, the relevant market section 2R defines what is a relevant market. So, the relevant market means the market which may be determined by the commission with reference to the relevant product market or to the relevant geographic market. It is not with regard to the whole market, but where that particular product is you have a dominant position, or whether such a firm is using its power and to have absolutely a dominant position in a particular market. So, this relevant market which we already talked about, there can be a product market or geographical market. So, the product market it comprises the products, services which are regarded as interchangeable or substitutable in nature, that is the product market. And the geographical market is the relevant geographical market, the area in which the undertaking concerns are involved in the supply and demand of the products and services. So, geographic market is very specific in nature, and in the other case there is the interchangeable products which is available. So, it is simply not the physical territory, but only the territory, the conditions of competition are severely affected by the activities of this dominant firm, and that is actually the geographical market. So, geographical market India, the complete India may not be a geographic market, but it can be a group of states or a region also can be taken into consideration for this particular relevant market, consideration of relevant market. So, uniformity of composition must be present in the relevant geographical market for consideration of abuse of dominant position. So, the relevant market considerations which is mentioned under section 19(6), that are the factors which the Competition Commission of India is going to take is regulatory barriers, then local specification requirements, then national procurement policies and adequate distribution facilities, and transport cost, the language, the consumer preferences, then the need for secure regular supplies, and then these kind of the characters, factors will be always taken into consideration for considering whether it is a relevant market considerations. Then also the physical characteristics and end use of goods are also one of the criteria for considering the relevant factor under section 19(6), and the prices are definitely one of the important factor. And 19(7) also enlists some of the factors to be considered for relevant product market. These are the physical characteristics and end use of products, then prices of goods or services, then consumer preferences, exclusion of in-house production, then existence of specialized producers, Then classification of industrial products, and this is also relevant for consideration of the abuse of dominant position. And if you look into the abuse, so what do you mean by abuse in the strength, that is MCX Stock Exchange Limited versus NES India Limited. In this particular case, it was decided very recently decided case in which clearly said that the position of strength in the market is not some objective attribute that can be measured along with the prescribed mathematical index or equation. So, it is not a straight jacket formula, rather it has to be a rational consideration of the relevant facts. This relevant facts mentioned under section 19, and also holistic interpretation of statistics, information, application of several aspects on the Indian economy is to be taken into consideration for these the dominant position, the determination of dominant position and the abuse of dominant position. And also there must be the if independent competitive forces are prevailing in the market, then you can see that the competitive forces are available in the market or exist in the market is an evidence of non abuse of dominant position. If there is no competitive forces in the market, which shows exactly there is dominance in the market, if that means the competitive process is absolutely not in the market, it is an evidence of dominant position by an enterprise in the market. So, here it is very clear that the how it is going to affect its consumers or the markets in favor. So, if the enterprise have a higher degree of strength, and then definitely there will be lot of pressures on the competitors as well as on the consumers. It is absolutely a loss to the consumers, and the competitors will be eliminated from the market. And also it may create an environment, a market situation or environment which would severely affect, distort the market conditions and the competition in the market. So, section 4 of the Indian Competition Act, which provides certain provisions and provisions which clearly restricts, limits or restricts, and these are which we already discussed about the type of abuse of dominance. That means the production, the limiting the production of goods or services and markets, then you are preventing technical or scientific development relating to goods or services, and you are preventing some kind of benefits to the consumers, then indulging in practices in the access, denying the market access, and then again the contracts, you prevent the delays from entering into contracts with the competitors. So, and also that is the constraint of trade, restraint of trade, and then again the relevant market, the control of relevant market and geographical market. So, in the group, the group which is mentioned in section 4 of the Competition Act is nothing but 2 or more enterprises which directly or indirectly in a position to exercise 26% of the voting rights, or you appoint more than 50% of the members on the board of directors of the other enterprises, then it will be you can say that you control the management and affairs of the other enterprises. So, next we will discuss about these combinations on, but if you summarize the factors to determine the dominant position, it is definitely the market share, size and resource of the enterprises, and then economic power of the enterprise, allocation of resources, larger allocation of resources, and then dependence of consumers on the enterprise. All these are the factors which we may take into consideration for the dominant factor. And some of the other factors which you can see, the market structure and size of the market, then again the source of dominant position, and then again the social factors, the social cost. Definitely there is a social cost which is attached with all dominant positions and those who are operating in the market. So, as a conclusion, and we can say that the dominant position which is directly or indirectly they are imposing unfair or discriminatory trading conditions on the supply of goods or services. Then secondly, they impose prices, unfair prices or discriminatory prices on the supply of goods or services, or which including even predatory prices, that means the prices which are lower than the cost of production. Then limiting supply, that is another area, limiting supply of goods and services to the market, and also preventing the technical or scientific development relating to that particular goods or services. Then fourthly, you can see the denial of market access, that is a refusal to deal with the other companies, even though there are prescriptions like the standard essential patents to deal with this kind of situations. And then making the conclusion of contracts subject to the acceptability of the market dominant power is also will be considered as the abuse of dominant power. Then using the existing dominant position to enter into another market. So, in toto you can see that all these activities which are considered to be prohibitive in nature in a market, and that is why it is known as the abuse of dominant position, and abuse of dominant position are is prohibitive under the competition law. Thank you.